I'm Ben Meiselas from the MeidasTouch network, and this is a breaking news alert. The Department of Justice has filed a letter brief to Special Master Judge Raymond Deary in the Mar-A-Lago search warrant matter. In this letter brief, they point out to Judge Raymond Deary that with respect to this specific group of documents at issue, which I'll discuss in a moment, Donald Trump has made frivolous and meritless and legally defective assertions of executive privilege, and that the documents that are clearly government documents, Donald Trump are claiming mine, that they are actually personal records when they're clearly government records. And in some cases, Donald Trump is even claiming both executive privilege and that the documents are personal records at the same time, which the Department of Justice and common sense would point out is legally inconsistent to make. If there is an executive privilege assertion, it can't be a personal record, since the very essence of executive privilege is that it is a confidential, deliberative communication made in the course of being the president, so that can't possibly be a personal record. What this letter brief relates to is about 25 or so documents. It's a really small group of documents that the filter team had segregated as potentially privileged records, and that they actually flagged for Judge Aileen Cannon back on August 30th. And so what happens is when a search warrant is executed, like the one at Mar-A-Lago, this is what frequently happens, to avoid the case team that's actually investigating the crimes, to avoid them from actually seeing potentially privileged records, attorney-client privilege records, which they're not allowed to have. A protocol is set forth in the search warrant where a privilege filter team goes in first before the case team, looks for anything in the area that's being searched that could be potentially privileged, segregates it, so then when the case team comes in, they don't see those records. And ultimately, if there's a determination that these documents are not privileged, they then go to the case team, and there's a organized process for that. Usually the magistrate judge who issues the search warrant goes through that, and there's a meet and confer that takes place with the government and the individual they're investigating. Obviously here, when Donald Trump filed this motion for judicial oversight with Judge Aileen Cannon, like on August 21st or August 22nd, basically 2 weeks after the search warrant was executed, and then she granted the motion for judicial oversight and started this frankly unlawful process and procedure with the special master that's kind of turned this process into disarray. The process here looks different than it normally does, but the special master, before dealing with the 11,000 other documents that were obtained in connection with the search warrant executed at Mar-A-Lago, is dealing with these filter documents first. There was a hearing that was held this past week on Tuesday where Judge Raymond Deary was very critical of Donald Trump's lawyers, and that's putting it lightly, but basically asked, where's the beef? What are you even claiming here? Just because you assert they're yours or say privilege doesn't make it so. And this, he said, I don't want to have games in my courtroom, and so just stop with the nonsense and let's actually go through a real process here if that's what we're supposed to do. Judge Raymond Deary clearly has no patience for Donald Trump's lawyers, and Donald Trump's lawyers obviously didn't take the advice of Judge Raymond Deary and have continued to assert that these records are personal records and executive privilege records when they're clearly not both. And in this letter dated October 20th, 2022, the Department of Justice is pointing this out to Judge Raymond Deary. So as we pull up the letter that's written, it basically points out the documents where there is still a dispute, and there's basically, from these 15 documents that are part of these documents that were potentially privileged, there's about 9 documents that are in dispute, which the Department of Justice says those documents should go back to the case team. There is no privilege issues here. There's no executive privilege. They're not personal records. They're clearly government records. And Donald Trump claims, no, they're either executive privilege or they're mine. And in this letter, the Department of Justice says what we're talking about here when we actually look at these documents, all these documents were were either created while Trump was president or used by him as president. They're not personal records. And for example, we actually have the records, I should mention, because even though these records were supposed to be filed under seal back on August 30th, the district court judge accidentally published the records publicly. So we got our hands on it. So why don't we just pull up Exhibit A to remind you folks. August 30th, 2022. This was a filing made by the Department of Justice back on August 30th, 2022 about these potential documents that are part of these Exhibit A potentially privileged records, which the Department of Justice says they should go back to the case team. But we're talking about 2019 immigration initiative, congressional clemency requests, Senate clemency request, document titled Executive Action to Curb Illegal Information and Move Towards Merit-Based Entry, contents of manila folders, marked NARA letters. We're talking about Rod Blagojevich, commutation, internal analysis. But all these documents, like these clemency requests and these immigration policies, Donald Trump is claiming what the Department of Justice is telling Judge Raymond Deary. Donald Trump is claiming those records as his own. He's claiming it's personal property when they're clearly government records. And the Department of Justice says just because Donald Trump says personal, he doesn't by fiat to turn a government record into a personal record, and the definition of a presidential record is clearly met here. And of course, there is no executive privilege here. And again, the government points out, look, if we pull up this October 20th, 2022 letter, document 1, you see the highlighted ones on this chart, this log provided in this letter by the Department of Justice. That's what's in dispute. So what they're saying here is this document labeled A001, Donald Trump, he's the plaintiff in this action still because he brought this thing before Judge Eileen Cannon. He's claiming they're personal records. Then as you go to the right, it says he's also claiming them as executive privilege. And the Department of Justice is saying there's no privilege here. You can't declare executive privilege against the executive branch. And their presidential records, their government records, he can't claim them as personal. So if we go now back to the Exhibit A, what that document is a draft 2019 immigration initiative, which Donald Trump is claiming is a personal record, which the government's saying obviously it isn't. And Trump makes those claims with congressional clemency requests, Senate clemency requests for all these criminals who he pardoned or granted clemency for. So the Department of Justice is saying, look, Judge, these are frivolous claims. These documents should go back to the case investigative team. And the Department of Justice, again, points out, the reasoning why as well, why they're not executive privilege. And they explain for the reasons that the 11th Circuit has already held in connection with turning over the 100 classified records, plaintiff Trump may not assert executive branch privilege to withhold documents from itself. Donald Trump can't assert executive privilege, preventing us, the executive branch, from having our own records back. And then even if there were to be an executive privilege claim, which there is not, against the executive branch, that assertion would fail here because the government has demonstrated a specific need for this evidence in its ongoing criminal investigation of Donald Trump. And then they explain you can't have both executive privilege and personal, claim they're your personal records as well. And then they explain that these are not personal records as well. And they explain the documents are government records because they are documentary material created or received by the president's immediate staff, or a unit or individual of the executive office of the president in the course of conducting activities which relate to or have an effect upon carrying out the constitutional, statutory authority, or other official ceremonial duties of the president. And they say just because Donald Trump says they're personal, he can't just claim it is. And if he wanted to say they were personal, which he couldn't, but you have to make that claim at the time of when the documents are being used, not after the fact in this process. What's going to happen here? Judge Raymond Dearie is not going to buy any of what Donald Trump's selling. He's already very skeptical. That's putting it lightly at Donald Trump's lawyers. He's very frustrated with Trump's lawyers. He knows they are playing games. He's saying, what's the beef here? What are you even claiming, Donald Trump, here? But here's the thing. We're right now talking about this small subset of literally 9 records or 15 records that are from the filter team review, these Exhibit A documents. We're not yet even talking about the 11,000 documents, which could be over 200,000 pages of records, which if Donald Trump follows what he's doing here, he's going to claim to the thousands and thousands of records that these are all personal documents that belong to him, because he just claims everything belongs to him, me, without legal justification. And this is the length to which Donald Trump would go to obstruct it. Judge Raymond Dearie is not going to have it. I think we're going to find some scathing orders written by Judge Raymond Dearie, because he had, in this telephonic conference that took place on Tuesday, Judge Raymond Dearie was like, I'm not having this. You're not playing games in my court. But ultimately what is going to happen here is that the 11th Circuit Court of Appeals has expedited the underlying appeal of Judge Aileen Cannon's order. So the 11th Circuit has already returned 100 classified records back to the Department of Justice because the Justice Department said that would cause us irreparable harm. Donald Trump tried to appeal it to the Supreme Court. He lost. Department of Justice has those 100 classified records. Now we're dealing with the 11,000 other documents. Judge Raymond Dearie started with this small batch of 15 documents. There's going to be a status conference in the next 2 or 3 weeks regarding the 11,000 other documents. And Judge Raymond Dearie even said at the last telephonic conference, I'm totally being kept in the dark here by what Judge Aileen Cannon's doing and by what Trump's lawyers doing here. I don't know if they're going to be making one claim of privilege or thousands of claims of executive privilege or that these are personal records. So I'm trying to be efficient here, but Cannon and Trump are making this process very, very, very difficult. He didn't say it in those exact words, but that's essentially what the meaning that he was conveying was. And it seems like Trump is going to try to make thousands and thousands of objections, but I think it's all going to be moot anyway. The 11th Circuit Court of Appeals set an expedited appeal by the Department of Justice of Judge Aileen Cannon's order. The very same logic, the very same legal elements that led to the 11th Circuit to find that the Department of Justice should get its 100 classified records back that were obtained during the August 8th search warrant. Those same elements, those same legal factors apply with respect to all of the remaining records and whether Judge Aileen Cannon should have asserted equitable jurisdiction in the first place. For a judge to insert themselves into a case where they don't belong and there's no statutory authority, in other words, that's what's called equitable jurisdiction, they have to find in a case like this that the Department of Justice engaged in a callous disregard for the rights of an individual. In this case, it would be Donald Trump in connection with executing a search warrant. Judge Aileen Cannon never made that finding, which is one of the things the 11th Circuit Court of Appeals pointed out when they said, as soon as you didn't make that finding, the 100 classified records should have been returned to the Department of Justice. Not only that, you shouldn't have asserted equitable jurisdiction. That's prong one or element one, whether or not there's equitable jurisdiction. The other elements are, would there be irreparable harm to the individual and the need for the individual to get their records back? And the 11th Circuit said there can't be irreparable harm and there's not a need to get records back because they don't belong to him. You can't steal records that belong to the government and claim that they are yours and then that would cause irreparable harm. As the 11th Circuit pointed out, under Judge Aileen Cannon's logic, every criminal, like a bank robber, would say, oh, I want the money that I stole from the bank back, give it to me. And then you'd be like, well, I guess you're irreparably harmed for not getting the stuff back that you stole. And the 11th Circuit said that that makes absolutely no sense. And so the 11th Circuit said, It was narrow because it was based on just 100 classified records, but that same analysis is not going to be different for the 11,000 other documents. There was no finding of callous disregard, therefore no equitable jurisdiction regarding all the other documents. That's why I'm 95 to 99%. I'll even go further and say I'm 99.9% sure that the Department of Justice is ultimately going to prevail in its appeal of Judge Eileen Cannon's assertion of equitable jurisdiction. This will mean that Judge Eileen Cannon will be taken off the case. The special master process will end. I'm sure Judge Raymond Deary will be like, what the hell was this process? Why was I even selected for this? What the heck just took place? I mean, Judge Raymond Deary is a law and order judge, a by-the-book judge, and Donald Trump making these ridiculous assertions of executive privilege and personal records. Judge Raymond Deary is not a fan of this. He's not buying it. He's not going to like it. And if the appeal takes until like end of November and December, and Judge Raymond Deary has to actually make some additional recommendations as part of his job, we're going to start seeing very, very, very scathing orders that even go far beyond his admonition to Trump's lawyers at this Tuesday status conference, and just saying, how ridiculous and absurd and legally defective Donald Trump's claims are going to be. So that was the letter that the Department of Justice sent to Judge Raymond Deary. We'll see what happens next. We'll keep you posted here on the MeidasTouch Network. We're on our way to 1 million subscribers, so hit the subscribe button now. It's free to subscribe, and it's important to help us grow this network that you subscribe. Hit the subscribe button right now. And in addition to subscribing, if you want to help grow this network, join us at patreon.com/MeidasTouch. patreon.com/MeidasTouch. There are a number of exclusive membership packages at patreon.com/MeidasTouch with behind the scenes footage, exclusive material. You could become an honorary producer of the podcast, get postcards from me and my brothers, and more. But most importantly, we're not funded by any outside investors. So by joining on our Patreon, you can help grow our media network, and it would really, really help. So if you're able to do it, I'd really appreciate it. I know there's a lot of subscriptions out there of other things that you subscribe to, but if you're able to join the patreon.com/MeidasTouch, it's super, super helpful to grow in this network. Until next time, I'm Ben Meiselas from the MeidasTouch Network.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.